particularly in states like Massachusetts where we allow it already. About the universal acceptance, but our question was really about a little more limited question about if a state like Massachusetts allows for that marriage, can the federal government impose a different definition on it? And that federalism question, can the federal government really do this, was argued much more extensively in our briefs and our arguments. I think it was a real question for the judges today, which was encouraging. And I too think that based upon, although we don't like to read the tea leaves, I think there is a very good chance, based upon the argument and the silence of some of the more conservative judges, that there are enough votes to strike down DOMA, which will allow in Massachusetts and hopefully across the country, states to recognize that this is a question of basic fairness for people, and the speed with which this is changing. Even Justice Roberts noticed the sea change. I think that everybody recognizes that this is an important issue of civil rights. We've seen in Massachusetts there's no downside to it. So we're hopeful today that at least DOMA will be struck down, and we are more hopeful that the public has seen in this country, whether the Supreme Court sees it or not, that this is an issue of basic fairness, and that is spreading across the country in a very good and fast way.